Hey guys, so this is going to be the topic analysis for sort of the more util style arguments, where I'm going to go through a couple of sort of the. First, I'm going to give sort of a topic breakdown, so I'm going to look at sort of the important words in the resolution and sort of outline how they sort of form as like a general guideline for what serves as sort of viable af and neg ground on this topic. And then I'm going to go into a couple different examples and provide you with some more of the legal background to the sort of types of arguments that have come out frequently on this topic. Wit is also doing another topic analysis, and he's going to go more in depth into a couple of other style of util arguments. So you should be watching both of our videos to get a sort of total sense of what exactly is going to be the sort of util style ground for this topic. So first, I think that the three important things to define in this topic are there are three main things to define. First is the term reporters. This is perhaps the most important one and the one that is going to create the most amount of confusion and chaos in the topic because there's a pretty unclear legal distinction as to who this term applies to. When you think reporters, you probably think of traditional journalists who like go out with a pad and pen and sort of and like write stories and conduct research in the field by conducting interviews, and sometimes they get run into stories that are high enough that they have to keep their sources confidential for various safety reasons or to ensure some sort of privacy to the person who's being named. But the question is, of course, is who counts as a reporter. While most of us would agree that what I just described is a reporter, the courts at the or the legal literature that I've at least read so far indicates that there's a pretty unclear distinction as to who counts as a reporter. Like the example I just gave, most people would consider a reporter, but given especially the rise of blogs and bloggers in the last few years, is someone who reports on the news just from out of their basement on their independent web platform. Do they count as a reporter, and are they entitled to if you were to take the app side of the topic, would they be entitled to a right to protect their confidential sources from forced disclosure? And if that is the case, if we are going to extend this protection to all reporters, quote unquote, then if there is no solid definition of reporters, then theoretically is this a right that extends to everyone within the United States? That's going to be a pretty tough legal question to answer, and this will serve as both a limiting and delimiting factor on the topic. It could potentially be limiting in the sense that we could define reporters to only apply to sort of the traditional journalists we typically think about, the ones that I described earlier. Or it could sort of broaden the realm of the topic. It could apply to literally any person who decides to write about what is going on in the world and calls it news. The second one is the right to protect. This one's a little more precisely defined. It generally means that journalists, there is no forced disclosure of confidential sources. So if a journalist is asked in court where they got who gave them the information that was in their news story, the journalist would have the right to refuse to name that suspect, or at least be protected from legal persecution if they refuse to cooperate with an investigation into the sources that they were naming. The third is confidential sources. I haven't found any great definitions as to what this is. In general, this probably refers to sources that a journalist or reporter uses in their articles in order to, but doesn't name by their actual name for various security or privacy reasons. This is the confidential sources are an important part of the literature because they often come up in discussions involving things like whistleblowing, in which case, say for those of you who don't know, whistleblowing is a practice in which a person who is embedded within a particular government or private institution sort of defects from that institution and exposes to the public some misdeed they believe the government or said private institution is doing. So, for example, the Edward Snowden leak is an example of whistleblowing because that is an example of a government employee who exposed to the media something that the government was doing that he believed to be unjust. Now, how that plays into confidential sources is that most people believe that some degree of confidentiality is necessary to allow those types of whistleblowers to come forward. Because the idea being that if a reporter is not able to keep their source confidential, then that opens up the potential whistleblower to potential backlash, to potential persecution, and as a result, being able to protect that name is considered necessary in order to prevent, in order to encourage whistleblowing to happen against practices that we would consider to be unjust by the government. Okay, so the major case law, or at least the major case that you all should read up and be intimately familiar with, not necessarily because it will translate into great debate arguments, but just because knowing this case will help you sort of understand the legal background and the legal underpinnings that go within this topic. And that important case is BRANZBURG v. Hayes. You can look up the sort of details and facts of the case for yourself, but this was the landmark case for reporter confidentiality regarding source disclosure, and it found its way to the Supreme Court, and it's sort of been the foundational case law for this kind of issue ever since. So the ruling of the Supreme Court in this instance, it was a 5-4. It found that forcing reporters to disclose confidential information, such as the source that they are keeping under wraps, does not violate the First Amendment, and that it is and that forcing a reporter to disclose their sources is justified if it serves a quote-unquote compelling state interest. Now, the reason that the Supreme Court reached this decision was because they had reason to believe in the particular facts of this case that if a reporter were allowed a sort of unhindered right to refuse to disclose their information, it would incentivize increased criminal activity. So therefore, it was in the compelling interest of the state in order to force the reporter to disclose the information that regarding their source. The side representing the journalists in this instance argued that this was a violation of a couple of rights. Mainly, they made a First Amendment argument saying that this was a violation of free speech. Forcing someone to disclose information, it was considered, they argued, was a violation of free speech. I'll talk about the sort of other potential legal ramifications of forcing disclosure of confidential sources in a second. But that was the main key issue in BRANZBURG, which involves sort of the free speech argument of, does forcing a journalist to disclose confidential information violate the First Amendment? In this case, the Supreme Court answered that question with a no. But a lot of courts' asks could revolve around overturning the BRANZBURG precedent to say that, to sort of restrike the balance in favor of the journalist and say that no, forcing a journalist to disclose their information is a violation of free speech, and then have an affidavit based around that. The logic of the Supreme Court in dismissing the free speech argument was that they sort of analogized it to how citizens, if you are prosecuted for a crime and you are being tried in court, if the prosecutor asks you to confess to your crimes, legally you must tell them the truth, otherwise you're committing perjury. So you must tell them the truth, and this is not. And while normally we would consider this to be a violation of free speech, or even a violation of the Fifth Amendment of right against self-incrimination, but in this particular case, the Supreme Court has recognized that no, if you are being tried for a crime, you must faithfully and truthfully admit to the things that you did, otherwise be risk for perjury. And the Supreme Court took that sort of logic and applied it to journalists as well, and ruled that they must be able to name their sources, just as a citizen can be compelled to confess any potential criminal activities. And the BRANZBURG precedent overall established a sort of guide for the Supreme Court and for this sort of case law, in that it isn't necessarily an absolute right to protection for the journalist, and rather that those protections for journalists must be balanced with the overall public interest. So there is an interesting sort of network, sort of patchwork of debate arguments that opens up from this. The immediate one, of course, being that sort of the precedent that the court will always sort of use a balancing test to weigh between freedom of the press and the public interest, means that there was sort of something of a chilling factor on journalism in general. Lots of the amicus briefs that were filed in the BRANZBURG case argued that should the court rule in favor of the state, that it would create a massive chilling effect on journalism. So an AF could argue that it is necessary for the court to overturn this precedent in order to restore full confidence to the journalism community, especially in an instance like now where sort of journalism is sort of under siege from both the sort of from a huge section of the American public, as well as high-ranking officials within the government itself, that it is necessary to sort of restrike that balance down. But that is a somewhat thorough overview of the BRANZBURG case, which I highly advise that all of you read up on as well, in order so that you understand the full legal background of the case. So I'm going to go through a couple these next few arguments are sort of legal arguments. These are arguments that are legal arguments that are touched upon by sort of the implications of requiring journalists to disclose their sources, and they touch on a different couple parts of the Constitution. The first one is privacy. So while privacy isn't a de facto right that's outlined in the Constitution, most people would argue that it is embodied in multiple different areas. The particular part we're concerned with here concerns the third-party doctrine. So for some background, the third-party doctrine is a general argument which says that a government surveillance is justified in any situation in which there is a third party present to the to a communication. So this doctrine was first established in the days when wiretapping used to be a thing, or was a much more prominent thing, I suppose. And the argument went that a phone call between you and another person is not technically a private conversation if there is someone who is able to eavesdrop on your conversation and can reliably be informed as to what you two were communicating about. At the moment when a third party is introduced to a communication between two private parties, the court will consider that communication no longer private. This is a legal argument that is used to justify mass incidental bulk surveillance. The argument going that internet providers are the third party in all internet communications. So when you send an email over Google to a friend, you and the friend are the two private parties in that communication, but Google, serving as the medium for that communication, acts as a third party to that communication, which provides a legal basis for surveillance. How this applies to journalism is, and there's an article that I've linked to in the bibliography in this PowerPoint, is that in an era where cloud computing is becoming increasingly popular and sort of journalism is moving into has moved fully into the digital realm, it is questionable as to whether or not any work a journalist does using cloud computing could potentially be subject to third-party doctrine arguments. And there are a lot of articles out there that are concerned about sort of how journalism can sort of work in an era of sort of pervasive government surveillance. And so there is a lot of ground and arguments to be looked to, specifically in the realm of privacy law, that relates to a journalist's ability to retain their own information. There's an argument to be made that the ability to have to not disclose information regarding your sources could be considered a form of privacy, which of course has ramifications for privacy areas in other instances, not one of which is bulk collection of data. The next one I want to talk about is the First Amendment. So this has to do a lot with the BRANZBURG stuff that I talked about a few minutes ago, in that the initial BRANZBURG ruling had to deal with free speech arguments. There are also some implications for the Fifth Amendment and the right against self-incrimination. So for those of you who don't know, the Fifth Amendment provides right against self-incrimination. In other words, that you have the right to not confess. You have the right to not incriminate yourself in your own crime. So this is why when cops arrest you, they inform you that you have the right to remain silent, because by remaining silent, at least during police interrogation, you are allowed to prevent yourself from admitting things that would be incriminated against you. So to sort of resurrect the argument from the BRANZBURG ruling, which would say that forcing a journalist to name their sources could be considered a form of self-incrimination, especially if the journalist is investigating sort of illegal activities, then that could be considered a violation of the Fifth Amendment. Okay, so I want to talk about the sort of this isn't so much a particular advantage or AF, but rather, a subset of AFs we're going to see, which is sort of an AF that creates a limited right on the right to protect against disclosure of sources. The topic doesn't set a precise limit on the extensiveness of this right. Theoretically, you could specify the right in only specific situations or carve out exceptions from that right. So you could say, we defend the right for journalists to not be protected from naming their sources, except for these types of journalists or in these particular types of situations. Hypothetically, that is theoretically legitimate. However, from a sort of fairness perspective, that could be considered theoretically illegitimate, since those kinds of AFs, the kinds of AFs that carve out one-off exceptions, would be considered neg picks to neg picks to AFs. So there's an argument to be made that writing this kind of AF would be considered theoretically illegitimate. However, it is, however, extremely strategic to consider sort of the limitations of a right, and at least most of the sort of literature I've read so far doesn't seem to advocate for a wholesale abandonment or wholesale advocacy of a journalist protection against the right to name against a forced disclosure of their sources. And there's probably more articles that talk about how a sort of more limited right to protect oneself against compulsion to name their sources would be a better policy type solution, or at least is one that is more based in sort of either legal jurisprudence from the Supreme Court or from potential statutory proposals that have been thrown out by various advocates. Likewise, with the sort of limited rights area, given the extremely vague legal parameters around the term reporters that I covered earlier, it is probably a little more, at least somewhat more theoretically legitimate to specify a type of reporter. So you could write an AF that potentially says, we protect the rights of journalists who, rights of journalists, but journalists who are only part of like formal news organizations. So think like the New York Times, the Washington Post, CNN, and so on and so forth. Likewise, you could say reporters who only cover certain types of things. So reporters that you could say you reserve a right for reporters who cover like immigration stories or drug war stories, etc., etc. There really is no limiting factor on the term reporters, which sort of blows up the area of analysis here, which also means that negs are going to have to be equally prepared to sort of engage on the front of specific reporters and do lots of specific research into the specific areas that journalists often go into and sort of the research they have to do and the impact that their stories have. And like I said earlier, this lends itself to better debate, since this sort of question about what do reporters mean, what does the term reporters mean, lends itself to the question, does a reporter mean anyone with a weblog, or is it limited to people like who are officially on the payroll of the New York Times? So now I want to talk about a couple neg positions. The first is the national security DA. This would be an argument that confidential sources, or at least a sort of universal rights to protect confidential sources, could encourage increased leaking, which jeopardizes key counterterrorism programs. So some people will consider leaks to be detrimental to national security efforts, especially when they implicate necessary programs that are considered important for counterterrorism. For example, the entire basis of the program that Snowden unveiled was to anticipate terrorist plots ahead of time by tracking large amounts of bulk data and searching for like terrorist type patterns within that data. While that isn't the greatest example, because there's a ton of evidence which shows that those sort of bulk data programs are ineffective, there is a larger theoretical argument to be made that establishing a right which says that a reporter can protect their sources in every single instance could lead to massive national security jeopardy problems in the future, especially in instances where a potential key program could be jeopardized by lower level government employees, given a world in which people are allowed to protect their sources no matter what the cost is. And a potential impact to this DA could include potential terrorist attacks or, at the highest scale, some conflicts involving multiple nuclear armed states, depending on the exact sort of whistleblowing that is going on. The next is federalism type DAs. So Witt mentions this, I think mentions this in his topic analysis, and it's a pretty important point of analysis that we have to think about. So multiple states have passed what are so-called shield laws, which basically do this, at least on the state level, the equivalent of what the AF would do, which is they allow a reporter, they protect a reporter from having to name their sources. And multiple states, not all of them, and I think over half of them have passed these so-called shield laws. If the AF were to implement a new federal right or enshrine a new constitutional right, that would necessarily have to overrule previously implemented state shield laws. And there's some interesting implications for federalism at that point. Specifically, it calls into question things like the anti-commandeering doctrine, or traditional principles of federalism regarding the sort of division of governmental affairs between the states and the federal government. And so, especially if we think that federal government acts will be popular, this was something important to think about. The one of the last things I want to talk about is potential counterplan ground. So, I think an amendments counterplan would be particularly useful, especially if the AF is focused on a lot of those sort of privacy or free speech type arguments that I talked about earlier. If the AF is focused on those, then hypothetically, a amendment to the Constitution that enshrines a reporter's rights to protect their sources would sort of solve all those advantages, because it is a establishment of constitutional law that hypothetically should solve any sort of precedent that is established by the AF. And it has the benefit of avoiding court DAs, because amendments can be passed without the court. It can be passed without the court, so you can pair a court's DA with this counterplan and ensure that the precedent is still solved while maintaining offense that relates to the court doing things being bad, whether or not that's like a court legitimacy DA or a political or a PQD DA, which we can cover more in depth later should you guys have questions. Sort of the converse of an AF I talked about earlier, which is that a counterplan that provides only a limited right of protection. So this is a counterplan that says that recognizes a partial right to protect confidential sources, but doesn't recognize an absolute right, and argues that there are exceptions. This can be tailored for specific AFs. So this doesn't necessarily. This can be tailored for specific AFs. For example, if it's a whole, this competes best against a whole res AF, and so the idea will be that we have pick out of a specific area that is probably not a good area of journalism, where we want people to be able to protect their sources no matter what, whatever that ends up being, whether that's some version of the national security issues that I talked about earlier. This counterplan would say that we would protect the right of journalists in any other area except this one, and then we put our DA in that area. This last point on this slide, for the limited right of protection counterplan especially, what you can do is you can tack on a clarification mechanism to solve advantages based on chilling the media. So the whole chilling the media argument is that sort of the uncertainty created by the court by the BRANZBURG case, and sort of a lack of a full right to protect one's sources means that journalists will be afraid to cover things out of fear of legal persecution. So what you can do with a counterplan is you can tack on a clarification mechanism, which says that the Supreme Court will declare that that this sort of legal reasoning does not apply in X scenarios. So, for example, if we were to run the limited right of protection counterplan, we would say that journalists have the right to protect their sources in all areas except one. The clarification mechanism would say that the Supreme Court would announce that would be the case, and that no journalist in that 99% of instances in which their right is protected will be prosecuted if they refuse to name their confidential source. By providing that sort of legal clarification or legal certainty, this enables journalists sort of the freedom and certainty to know that they can sort of investigate stories without fear of legal persecution, unless they happen to fall into one of the clearly defined areas in which the counterplan has said that the government will not recognize a right to protect one's sources from forced disclosure. So this is a couple of sites. The Deniston article is just a quick like status quo check on like do if journalists have the right to protect. The Kelly article is an article that is in the Dropbox that is that contains all the that contains a lot of the cloud computing and privacy stuff that I was talking about earlier. And the Johnston and Wallace article sort of goes into like the legal ramifications of sort of the vague definition of journalist that